I'll write this as a composite illustrative cold case narrative, fictional names, generic setting, rather than attach invented forensic facts to an identifiable real person, standard practice for this format to avoid spreading misinformation about real cases I can't verify. Here's the script. They convicted Raymond Kessler of murder in 1988. Then, in 2022, a records clerk found a ballistics report, one that was never entered into evidence, and it doesn't match the gun they say killed the victim. The official story was simple, and for 34 years, nobody questioned it. Kessler was arrested 6 days after the shooting of Daniel Voss outside a closed hardware store in Tulsa, Oklahoma. Police said Kessler's revolver, a .38 recovered from his truck, was the murder weapon. The state's ballistics expert testified the recovered slug was consistent with that revolver. The jury took 90 minutes. Kessler got life. No appeal ever succeeded. The case file was closed, boxed, and shipped to a records warehouse outside the city, where it sat, untouched, for over 3 decades. The first crack came from a woman named Sharon Yude, a records technician digitizing old case files ahead of a warehouse move. Buried inside an unrelated folder, labeled for a burglary case from the same precinct, same month, she found a single carbon copy sheet, a ballistics comparison report, dated 4 days before Kessler's trial began. It bore the crime lab's letterhead, a case number matching Voss's homicide, and a signature from a firearms examiner whose name never once appears in the trial transcript. The report says the slug pulled from Voss's body was fired from a different caliber weapon entirely, a .357, not a .38. It was never logged into the evidence system. It was never disclosed to Kessler's defense. Here's where the contradiction becomes impossible to explain away. At trial, the state's expert, a different examiner, testified under oath that the bullet was consistent with a .38 caliber revolver, the one found in Kessler's truck. He never mentioned a second analysis. He never mentioned a second examiner. Under the rules of evidence in 1988, any ballistics comparison performed on behalf of the state had to be turned over to the defense, whether it helped the prosecution or not. That's the doctrine, Brady disclosure. It exists precisely so an inconvenient report can't just disappear into the wrong folder. And yet this one did. 2 examiners, 2 calibers, 1 trial that only heard about one of them. So why was this report never subpoenaed, never surfaced, never even searched for? Because nobody outside the crime lab had the authority to request its internal case logs. Not the defense attorney, not the judge, only the lab director, and lab directors don't audit their own examiners' contradicting conclusions. The lab operated, by policy, on a verified findings-only release system. Only the report the lead examiner chose to finalize left the building. The second opinion, the .357 finding, was filed as a preliminary worksheet, which under the lab's own retention rules didn't legally qualify as discoverable evidence. A technicality. A drawer nobody was required to open, but the misfiled report wasn't the strangest part. Cross-referencing the newly surfaced case number, Yude found that the burglary file it was buried in belonged to a man named Everett Doss, arrested 3 weeks after Kessler, released without charges, and never mentioned anywhere in Kessler's trial. Except Doss owned a .357, registered, legal, on file with the same department. Nobody connected the 2 files in 1988 because nobody was looking. One misplaced sheet of paper had quietly linked an unindicted man, a mismatched bullet, and a convicted one, for 34 years. What this means for Kessler's conviction is still being argued in a Tulsa County courtroom. His attorneys filed for post-conviction relief within a month of the discovery, arguing the state suppressed exculpatory evidence in violation of due process. Prosecutors counter that a misfiled preliminary worksheet isn't proof of anything, just an internal disagreement between examiners that was properly resolved before trial. But no one has explained why the resolution process left no paper trail, why the dissenting examiner was never called to testify, or why his report ended up in a stranger's folder instead of a shredder or a shelf. Somebody benefited from that report going missing. It just isn't clear yet who. Everett Doss died in 2009. He was never questioned about the ballistics match to his own weapon because no one ever knew there was one to ask about. So the question that's left, the one the courts haven't touched, if the wrong caliber convicted the wrong man, was it an accident that the report disappeared into someone else's file? Or was that exactly where somebody needed it to stay?